It is Saturday, February the 21st of 2026, and you are entering the court gallery. Ladies and gentlemen, everything is bigger in Texas, and today it is no exception. We have two very big dockets, starting with Judge Stevens and moving to the Justice of the Peace in Austin, Texas. So, buckle up, ladies and gentlemen. It's a long morning in Beaumont, Texas and Austin, Texas, and it all starts right now.
We call the matter of Caleb Baker. Is that you?
Yes, Your Honor.
Go ahead. Did you stick your finger into an electric socket?
I was in a hurry. I didn't want to be late. I wasn't late.
I wish I had hair on the top of my head, though. Now that you're reminding me. Okay. Earlier, the defendant entered a plea to aggravated assault, a first-degree felony. The pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
I've reviewed it, Your Honor. I don't do particular corrections.
None from the state judge?
This made a part of the record for all purposes. Is the complainant here, the victim here?
No, Your Honor. Nothing I'm aware of.
Well, I got a problem here. He says the defendant has a version. I've read that.
Yes.
And then contact was made with the victim who strongly objects to the defendant receiving probation.
Yes, sir.
He advised he has not been notified of the status of this case until this statement.
He was before that because we talked about it right before I made the offer. He just doesn't want him getting probation, wants him to get pen time.
Well, I mean, he says the defendant tried to kill him. He shot over 5 rounds on purpose. He tried to kill me. I mean, he's pretty sensitive about that. Meanwhile, the defendant says it was all the victim's fault.
He's not saying it's all.
You were-
fault.
Okay.
I disagree. He's contextual.
Let's read this together.
He's
No, let's read this here.
He's not
Defendant's
saying it's
version.
all.
I picked up my wife from work. We were coming down MLK in Franklin, and there was a vehicle with its hazards on. I had my blinker on to get over to the next lane. When I started to move over, I did not see a speeding car coming, and all I heard was screeching tires. After I slammed on my brakes, the victim pulled up next to my car and started screaming and yelling at my wife, kids, and me. The victim stated, "You are lucky you have those kids in the car. I'll air this bitch out." We kept driving and he followed us. I saw a red laser pointing at us and I took off. The victim pointed the laser again and turned on the feeder road. I turned on the feeder as well, and that's when I pointed my gun and shot at him.
Right. He's not saying he knows he's at fault here.
It sounds like self-defense,
No.
doesn't it to you?
But it's not deadly force. A laser.
Well, why did you-
He's not justified. He wasn't justified in what he did.
I don't understand. I don't understand this. You're trying to take sides on this, both sides.
No.
Are you the victim or not?
No.
Are you the victim or not?
He's looking at it. You're not a victim.
He wasn't at the scene. You were the one at the scene. Were you defending yourself?
What
Yes, I was defending me and my family.
from a laser pointer?
I don't know exactly what it was, I mean.
Yeah.
Well, he may think in his mind, Your Honor, but from a legal standpoint, I think for self-defense, he used deadly force. It would have to be in response to deadly force. I don't know that what the co-actor did rises to the level of unlawful use of deadly force. He would be entitled to get a jury instruction on self-defense. So he's not obviously an expert on the law of self-defense, but in his mind, he knows he was acting inappropriately when he shot at the guy.
Okay.
I mean, there's no question about that. Right, Mr. Beck?
Right.
Yeah.
And if you look at his criminal history, I mean, it's not extensive. It doesn't, it's not like he has an extensive history of any kind of violent related offenses.
I've done this long enough to know, to see. You got two different stories here. And he thinks,
He thinks it's better to plead to try to get the probation versus going to a jury for a decision, Your Honor. Yes. And I mean, you can speak to the court. I think he's extremely remorseful about this. He's been away from his family for 4 months because of this stupid decision. But it's
Yes.
contextualized. I mean, there's context here. He's not just some maniac driving around the road shooting people. That's not what happened. I mean, it happened that he shot at somebody because there's a context to that. There's two people here doing things on the roads, and he's not operating his vacuum when around randomly shooting at cars.
well, he's going to shoot every time he sees a red laser pointing.
No, I think that he's learned.
Oh, that's what he's done. That's what he says. That's why he did. I saw a red laser pointing at us and I took off.
After
The victim,
I'm sorry.
What?
you love to control her.
The guy threatened me.
The victim pointed the laser again and turned on the feeder road. I turned on the feeder road as well. And that's when I pointed my gun and shot him.
He had been threatened by him. It wasn't just a laser shot. There was words exchanged. He was threatened. That's actually the situation. Again, I don't think he's going to do this again. He's learned his lesson. But he had his family with him. And he was scared and he acted inappropriately. I mean, that's what the PSI addresses there through anger management or moral recognition.
I think that
Recognition, then these things can be addressed in a remedial context versus putting them in.
So what about the victim who strongly objects to him receiving probation? Honestly, because of the severity of the situation, he tried to kill me. He shot over 5 rounds on purpose.
Well, Your
No
Honor,
regard for my own family or anyone else. That seems serious.
I would say that it's the state's case and the state's decision, Your Honor. Obviously, the court takes into consideration what victims express desire, but I'm reminded on many times when I have uncooperative victims who want to drop cases that the state reminds me that it's the state's case and not the victim's case. So that's looking at the totality of the circumstances.
It is.
We have to do.
But since one of the victims not have a board.
No.
They do, they should.
Okay.
But this is not some
Okay.
pristine victim. It's not-
What's state asking?
Well, I'm asking for pen time, the 6 years pen time on the 6-year cap. And I think that last sentence in the defendant's statement is what turns the whole thing. When it says he pointed the laser again, it says he turned off on a feeder road, and then the defendant turned off on a feeder road and followed him, and that's when he shot at him. Because the guy was veering off and he shouldn't have gone after him and shot him. That's what gets him pen time.
Well, do you want to address it, Mr. Hagan? What happened?
Start from,
Tell the judge, tell me.
so start from the beginning.
Yes.
So start from the beginning, I had, me and my wife and my 3 kids, my 7-year-old son and my 5-year-old daughter and my 2-year-old daughter. We were coming down MLK Street. We got to the light. The hill before, Franklin and MLK Street. And, there was a car that was in front of us with their hazards on. And I had my left blinker on to get over in the lane next to them so I can pass them up. And I didn't see the car coming down the hill so fast. I don't know how fast he was going, but he wasn't going fast. All I heard was screeching of tires. And that's whenever I slammed on my brakes, thinking that somebody was coming through the light on Franklin. So I kept on going after I realized that nobody was on the side that was coming to hit us or whatnot. So the guy, as soon as we passed the light on Franklin and MLK, going northbound toward the north end of Beaumont, he pulled on the side of us and was yelling at me, my wife, and kids. And he was looking around in my vehicle and he seen my kids were in the vehicle. And he said, "You're lucky you got them kids in your car. I hear this, excuse my language, bitch out."
What do you think that meant?
To shoot my car, kids don't like him.
What happened?
So what did he do? What did you do when he pulled the gun out at you?
So
Did you see the gun pointed at you?
I've seen
Did you
some,
see the gun pointed at you?
not technically, no, sir.
Not technically. You know,
See
you
that?
mean by
Yes, I mean,
clairvoyance? What? But imagination?
It was in the shape of a gun. I don't know if it was an actual gun, but it had a laser on it. I don't know exactly what it was. It was shaped like a gun.
Then there was a laser sight on it.
Yes,
What color?
it was red and it hit me in my left eye.
Oh, then what happened then?
So when we got to Calder and MLK Street at the light, we got stopped by the light. He pulled over on the side of us again. And he was ranting and raving again. I didn't know what he was saying because I did turn my music up whenever the incident happened on MLK and Franklin, past MLK and Freshies. And whenever the light turned green on Calder, I kept on going. And whenever we got to the light on MLK and the I-10, that's whenever I seen the laser again. And the resemblance of a gun.
No, then what happened?
So that's whenever I took the feeder road, as well as he did.
No,
Yeah.
you went after him.
Yeah.
Why?
Don't know. I mean, to be clear, like, I guess I was nervous. I was scared. I mean,
So you went after him thinking he had a firearm, you have kids in the car, and so you followed him?
I'm not necessarily.
That's exactly what you're saying.
I wasn't trying to.
You could have gone anywhere else, but you decided to follow him. You can get your your family in harm's way when you could get out of harm's way. You put them in harm's way.
You did that? I think that's where probation or mediation come in versus punishment, because he does have a wife and 3 kids that he's taking care of. He's been in jail for. He has, I think he has remorse.
Yes, I'm fully remorseful. You know, I don't even want to own a gun no more.
How many times did you shoot at him?
To my knowledge, 3 to 4 times.
Were you shooting at him or at his car?
At his car. I didn't necessarily aim just directly at him.
So if you're driving a car and somebody shoots at your car, they can say, I wasn't shooting at the driver, I was just shooting at his car. That's going to make you satisfied?
Also, I was scared, like I said.
With your children in the car, he was no longer a threat to you. You chased him down. I mean, right? You made a conscious decision to either go after him with the kids or turn away and get out of harm's way. If your story is true,
Yes.
but you decided to put everybody at risk. Your family that you love so much,
And I will
that you're
fully
supposed to
regret
care
that.
for them. Huh?
I regretted it every day since I've been arrested on this charge.
I would
I've been in jail.
I know the court might consider shock probation,
Yeah.
but with an affirmative finding of deadly weapon, it's not eligible.
Here's the other thing about it. The victim says there are 5 bullets in the car, 5 bullet holes in the car. No, his story is still not even close. It's 3 or 4.
In a situation like that, you can lose track of how many times. I think if there's 5, then he shot 5. You confess that you shot 5 shots.
Yeah, if there's a problem.
Now it's 5? Is that your final answer?
It could be 5.
It was 3
Yeah,
or
it
4
could-
a
it
little
could
while
be
ago.
5, yes.
The story evolves
Well, Your Honor,
as you're standing there.
in the context of a shootout, people lose track of what's going on. Time compresses. I'm just trying to.
Jeez.
Where
As
there
though
was
I've never been in one of those.
a gunfight in a car.
Yes, I know how that exactly works, sir. Anything else?
We're asking for probation, Your Honor. As I said, he can't get shock probation.
How much time does he get credit for?
But for the deadly weapon finding, you can be eligible for shock. He's been in jail 4 months. You could get 6 months upfront time. But I really think this person is a good candidate for probation. He has genuine remorse. I know he feels bad. He has a wife and kids that are there to support him. And in the heat of the moment, he made a bad decision. And again, you can look at his criminal history. He doesn't have any
How long have you been
history.
in jail?
Since the day before September 30th. I was booked in at 10:30 p.m. on September 29th.
How many cases?
I'm sorry.
140 days.
And how many cases do we have in there where the state comes in with write-ups from the jail when they've been disciplinary problems in jail? I mean, he hasn't, in 4 months, he hasn't got a write-up.
They seldom do.
Well, that's not been my experience lately. They get write-ups all the time.
We're
People.
gonna start keeping a score. I've been doing this longer. I'm here more than you are. I know when they produce write-up.
Well, maybe
It's not that often,
next
sir.
door that I'm dealing with write-ups and people all the time.
I
I'm
don't think
sure if
these, I don't think these people are irresponsible.
If he had gotten in trouble in jail, people would be aware. But it would make it.
Anything? Anything else by anybody? Okay. Nothing further, Sam? All right. If not, I'm going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence in the record supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt, and I find you guilty beyond a reasonable doubt of this aggravated assault with the use of a deadly weapon. The fact of the matter is that this court is going to have to has 2 different stories, 2 different versions of the events. But at the end of the day, the victim has 5 bullet rounds that you shot into his car. I don't see any on your car. You had the opportunity with, of all things, your family in the car to turn away. You did not. You turned into harm's way. I don't know if it's rage or what it was, but you went after him and shot at him. And he's the victim in this case, Mr. Sampson, strongly objected to you receiving probation. And I see your statement here. But this last sentence, your statement gets you. He turns on the feeder road. You turned on the feeder road as well. And that's when I pointed my gun and shot at him. And anyway, yeah, you were going after him at that time. There is enough evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense of aggravated assault. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for time you have served in accordance with this case. Also, the judgment will reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. This is a tragic situation could have been worse. We could be dealing with children dead than others. And everybody needs to, in difficult times, need to somehow stop, think, and appreciate what kind of tragedy can occur by the next choice you make. And sometimes with ego being the way it is, people want to go after issues that they perceive as trouble. Under your situation, the trouble had left, and you went and sought it out again. And that was the problem with the family. Oh, that is
Hey, is there a possible that holding my wife goodbye?
it's the bailiff is in control of you now.
I love you. Love you. I'm gonna call you.
We now call 25 CR 519, the state of Texas versus Joshua Guidry. You are Mr. Guidry.
Yes, sir.
Present with Ralph Kindler, your attorney and the state's attorney. There is a first amended motion to revoke probation that has been subsequent to an original motion that was on December 9th. And then this first amended is filed January 28th. About 3 weeks ago, two to 3 weeks ago. What are we doing today?
He's gonna, if the court could go through the entire appeal and pleadings and requests.
First amended motion to revoke. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Does he waive a formal reading of this? Can we proceed in summary?
So
In summary, this first amended motion to revoke unadjudicated probation states that on August 7th, 2025, that in this court you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true?
Yes, sir.
And that was a second degree felony. And you were placed on 10 years deferred or unadjudicated probation. Was all of that true?
Yes, sir.
Allegation. There are 9 violations. We haven't done this one.
No,
We hadn't had one state you committed the offense of public intoxication on or about October 10th, 2025 in Jefferson County. True. What is he? Let's
She's
just
not
say
pleading anything evidently. I don't know why I'm going through this.
I think we've discussed it with him. I just want to make sure he knows.
Is he going to plead untrue to the indictment?
No,
To the
not
motion?
the entirety.
What? Okay, tell me.
We have to go through it. I don't remember if it was the administrative violations that we were going to.
Okay, none of the substantive.
None of the substantive.
Okay, so the first 4 are crimes: public intoxication, PCP possession, public intoxication, and then number 8 is public intoxication, and 9 is public intoxication.
We were going to plead true to 5, 6, and 7. And then request for bond and have an updated pre-sentence report and give the state an opportunity to prove up the other allegations. I don't know what the problem is with that. I mean, what,
Nothing except that he's just pled true to violating conditions of probation, which would be the same conditions he'd probably have as a bond. So why does he need a bond?
he's entitled to bond because it's deferred.
Well, it would be, but you just pled true to some allegations, so the judge can decide. He doesn't have to give him a bond after he's pled true to those. He could actually revoke him, send him to prison right now.
If you don't want to get an updated PSI, they can proceed on the administrative violation.
What do y'all want to do?
I would plead true to the administrators and request a bond. If Mr. Laird doesn't want to attempt to proceed on the substantive allegations, we can
Oh, we were
start the hearing today.
We were set for an announcement today. You want to set it for a hearing? We'll set it for a hearing. We'll have a hearing.
I'd like him to have a bond.
I know.
Anything.
Well,
Yeah, I'm just trying to simplify things, but go ahead and plead into the administrative violation.
that's not simplifying things. It just, all it does is just makes it where you've got 3
Okay,
allegations.
what we're going to do is, we're not going to take it in installments. We're going to do it all or nothing. Let's set this for a hearing. When can y'all be ready for a hearing? 2 weeks?
Yes, sir.
Could he
2 weeks.
have a bond for that?
And on the bond, the court is reviewing what does he have now? Is there a bond
There's
for that? Huh?
There's
In Mr. Guidry's case, Mr. Guidry, you know how many times you've been convicted. I mean, it's your life, right?
Yeah, but the PCP,
no,
No, that's what you're charged with. Here, phencyclidine possession. We're going to postpone that to another time. Talking about your criminal history. You know what your criminal history is.
yeah.
Okay. How many convictions do you have?
3,
12.
conviction you wouldn't.
How could you know your life better than me? We go back to on 2011, failure to identify, giving false or fictitious information to police. You were convicted of a misdemeanor and confined. It looks like 4 days and probated for 6 months. In 2012, you were placed on deferred probation for 3 years for illegal possession of controlled substance. Later in 2012, you were convicted and sentenced to a theft, a Class B misdemeanor. And I'm not sure what the confinement is. I can't read it very well. In 2015, convicted of manufacturing or delivering a controlled substance and given 7 years probation. And in 2020, misdemeanor of DWI, convicted and sentenced to 90 days. 21, Class A misdemeanor, resisting arrest or search, convicted, and it looks like 10 days in your confinement. So that was Class A misdemeanor. Then a DWI, 30 days in jail in 22, convicted, sentenced to 6 months in the state jail for illegal possession of controlled substance. 23, convicted, 20 days confinement, harassment of Class B misdemeanor. In October of 23, state jail felony, 6 months for illegal possession of controlled substance. In January of last year, 25, Class A misdemeanor, resisting arrest, confined for 30 days. And then in March of last year, second degree felony, assault on a peace officer, and that's when you get this 10 years deferred or unadjudicated probation from me. So 12 times, and you've been handled, and you're currently on deferred or unadjudicated probation. You were convicted of all the others. Your criminal history is terrible. And now you are alleged to have committed drug offenses, public intoxication, etc.
Well, again, my suggestion was pleading to the administrator. You can get an updated pre-sentence report and come back for sentencing.
State
He's got new offenses. I mean,
wants
why
to
do we
handle
skip
that.
those?
We're gonna have
Why would we skip
a
them?
hearing on all of it.
Because then we get.
Your bond is $250,000 plus if you post a bond, you're gonna have a DPS class. That's a condition of
I
bond.
suppose you're, this wouldn't have an updated PSI. What do you
Then we'll have a hearing
But
in 2 weeks.
We'd be able to get an updated PSI before sentencing.
Maybe. We'll see what happens. We'll see how that shakes out.
All right.
Okay, thank you. Larry Johnson. What's this one?
Same thing. Well, you'll be sure now.
What's he gonna do with any?
I'm playing the truth to it.
I take the same position, but if we don't, for some reason, to piecemeal these things.
Well, it's fine if you'll get out of jail and something like.
You know, we're not gonna agree to that.
These guys are sitting in there for months.
This guy's been sitting there for 30 days.
I know because they hired me.
Am I hearing the right one? Y'all both playing with me? I scared one off. Is that a challenge?
All right, we call 19-3-3-3-3-8. The states of Larry. Johnson. No, well, we go through this one, no, we don't do installments. There's a motion to revoke unadjudicated probation that's been filed as of January 9th of this year. It alleges that you're on probation for 10 years. Defer to unadjudicated probation. Assault and the maybe violation of probation by God. The probation officer that they're not being intoxicated by being six, being a location other than your residence after curfew at 10:52 p.m. Failing to abstain from all intoxicating substances. By having alcohol consumed, and you were approximately 3 times the legal limit of your intoxication including. Was not a good Christmas. I'm sorry. What we
How many of them?
0.223. Yeah. 0.08 is intoxicated. 223 is almost 3 times. Multiplied.
Something. That's not the look to this. No, you don't have to.
Well, there was a breath test that indicated this concentration to be 0.223. I don't. Do y'all have a?
I'm interjecting here because the audio is horrible and I'm jumping forward. And we're going to just get past this little chunk of this video and move on to the next one, which is right about here.
Here.
Thank you, Judge. I appreciate it. See if I can.
Okay. We've got an indictment here, 25 CR 1791, that accuses Michael Wayne Osborne, that's you,
Yes.
correct, of the state jail felony of burglary of a building. And it also alleges that you have a fire forgery conviction out of this court in 97. And then paragraph 3 goes on to allege that after that 97 conviction of forgery was final, you committed the offense of unlawful possession of a firearm by a felon and were convicted of that in Orange County, Texas. So this state jail felony then becomes punished as though it was a third or second, because they're in sequence. If you don't interrupt me, okay? That's rude, and we can't all speak at one time. Hold on, you're going to get a chance to speak. So this appears to be indicted as a state jail felony, though it's punished as a second-degree felony if found guilty. So you were looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing in this charge? Now you can speak.
I do not.
Okay, good.
Yeah, well, I guess I started off.
There are several things that you filed here. Let's see, you got a motion to dismiss counsel that you filed. What was the date on this? I don't see it's undated. And that Miss Minaldi has been appointed to represent you. Are you able to hire your own lawyer?
No, I filed a motion to proceed pro se and to be admonished. I also filed a motion for recusal of
I
the
know,
court.
I know. I just asked you a question, sir. Just, are you able to hire your own lawyer, though? I'm just
I'm
trying,
proceeding pro se.
this is yes or no. This isn't
No.
a hard one to figure out, sir. Are you able to hire your own lawyer if you wanted to, though?
No,
Okay, you're, because you're in jail and you don't have an income. All right, you're indigent then,
yes.
right? Okay. All right, this, we're gonna take these one at a time. Motion to dismiss counsel. Here, why do you want that? Because this lady is here to represent you. You believe you could represent yourself better? Is that what you think?
Well, I'm sure you're aware, Judge, that I've been through this before and I represented myself. I have no problem with it. It's a barrier of communication when she offset this case and didn't network with me. Then I didn't want this presiding court even to, adhere to the alleged affair. I don't want to be tried before this court. Not with you presiding.
Why is that?
Well, if you don't recall, you should remember 8-9 years ago, you refused my agreement, and then you still sentenced me, and you never gave me my back time. And I don't see how we can entertain this today when I filed a motion to recuse, and you still entertaining the case.
Yeah. Well, first of all, back time, I don't have number one, you're so wrong because back time is not in this court's discretion. It's law. If you have time credited, you have to be awarded to this. And the court has never in 20 years denied back time that is allowed by law. So that doesn't make any sense there on that one. Number two, you can certainly represent yourself at any time if you wish, so long as you are completely aware and appreciate that the people who represent themselves pro se generally are not successful because attorneys are more profoundly aware of the rules of evidence, the penal code, the code of criminal procedure, and other laws that are used in the trials. Representing yourself is always a disadvantage. That's why it's a long statement. People who represent themselves have foolish people for their own clients. That was something that was part of the history of law before I was born, because there's not a lot of success at doing that. And when you're not adept at the rules of law, then you have a disadvantage. But you're an adult, you get to make your own choice. If you want to represent yourself, you just have to know that when you represent yourself, you're going to have to follow the rules of law and the evidence and the court of criminal procedure and the rules of criminal procedure and the penal code and any other rules that may come into the trial process. Let's see. And, you'll be able to represent yourself if that's what you clearly want. Have you ever represented yourself in any criminal proceedings before?
Well, I'm sure you are quite aware that I have.
Well, no, that's just yes or no. And just play like I haven't had 50,000 defendants in this court.
Wow.
You're going to have to refresh my memory. Go ahead. What have you done? What's your experience in
Well,
representing yourself?
I started out with, Your Honor, with the fact that I filed motions that the court is not adhering to, and it seems to me that you're depriving me of due process because I don't want this court to preside, you to preside over this case.
Well, when you have good cause, just because you don't want,
Okay.
if
Rule
you
18,
do you want to interrupt me all day? We can't both speak because when you speak over me, this lady can't take what you're taking down, what you're stating. And it's rude, number one, but it's impossible for her to take what you state. Let me speak, then you'll get an opportunity to speak, okay? All right. Look, the Constitution of the United States does not state you anywhere that you get the choice to make your joy, to have a judge of your wish before you. And that's, you get a judge who is a lawfully presided judge, and that's what you get. Just because you don't like me to preside over your case, that's not enough to grant your wish. Then I have a motion to quash an indictment here that you have filed, and can you summarize the reason that you filed this?
That was predicated, Your Honor, because it fails to state, I don't have a document, probable cause, information, or anything to go by. And first of all, I never entered any building, broke into any building.
But that's not, that's what we deal with at trial. But the four corners of the indictment, what's
All
wrong?
four corners, it doesn't meet the element of burglary of a building.
What does it fail to state? Because it states
given notice that I fully entered, partially entered, something to that effect, in which that would probably give me the benefit of defending myself against.
Okay. In summary, this states the elements of the penal code of burglary of a building clearly in this paragraph that on or about October 15th, 2025 in Jefferson County, Texas, with the intent to commit theft, you intentionally and knowingly entered a building or portion of a building not then open to the public without the effective consent of the owner. Those are the elements of burglary of a building. Anything else? What was it missing? What was the element that's missing that's in the penal code that you're saying?
Into the building.
Oh, but it's an allegation, sir. It's not, that's what we do at trial, it alleges, it's what the allegation is. That's why we have a trial, and that's why you get to present evidence, the state presents evidence, and a jury makes a decision. Everybody who pleads not guilty contests what it says. The question is the four corners of the indictment. Does it allege the allegations that are required for the commission of a crime? And it does. That's why we're going to go to trial. So that's denied.
Yeah.
The motion to quash is denied. It does
I'd like a copy of that.
properly fit the elements of the indictment. And you filed it more than once here. There's a motion to quash on December 19th. What's the difference?
I never got an answer. This is why I refiled it.
That's why we're here today. The motion is denied.
This
Let's
is
see.
nothing but
Wanting to advance pro se. What, you're just so rude. Interrupt the court. I told you have a chance to be heard, sir. You can't help yourself. How many times we learned that in second grade. Not that our teachers would scold us. Don't be rude to others and don't speak over others. You're going to get a chance to speak. Okay. Wanting to advance pro se, that's granted. You're going to get that. That's all. Now, that's all I have here. The motion to quash, hold on, the motion to quash is denied. The motion to proceed pro se is granted. That's another pro se, that's granted. Motion to dismiss counsel. That's granted. Anytime you want to change your mind on that, though, I would urge you, let me know so a competent attorney can be appointed to represent you. Does he file something? I'm sure he's not able to pay and Mr. Osborne is deemed a transient. Is there something in here that shows he's indigent though, so that we can appoint somebody? There is an affidavit of indigence that was never signed by you. That needs to be filled out
Yes, sir.
so that if you, and it looks like the magistrate, it looks like Judge DeRuin
Yes, sir.
went over it, but you wouldn't sign it or fill it out.
No, I filed to proceed pro se and I filed for an examining trial. I requested one immediately.
Okay, but here's the deal. Anytime you want to change your mind, which is the right you have under the Constitution, to have a lawyer represent you, what would happen to happen? We'd have to stop everything we're doing and get you to fill out an indigent form. If you fill out an indigent form now, it's in there ready to go in the event you change your mind.
All right.
But it's your call if you don't want to do that, but it stalls everything, you know? I would urge you to do it just to have it as a safety. Okay, sir?
But one thing, did you get the motion for an investigator? I sent that as well.
I'm looking at all of this. And okay, motion to dismiss. There's no investigator in that. Then the pro se motion. Motion to quash the indictment. Another motion to quash the indictment. It says wanting to advance pro se. I'm treating that as a motion for pro se, and I don't have it. That's it.
Okay.
That's all I've got here. And then here is there's something about this says motion to recusal, and then it refers to Judge DeRuin, though. Establish the wanting for examining trial. Is that right? Is that what
Yes,
you-
sir.
Okay, you don't get an examining trial if you have been indicted. If the grand jury indicts, which they've indicted in November, an examining trial is no longer an option. Says you are illegally confined in the jail. Information indictment, that's paramount. Does it said John seems to stop. What is that? Step aside, I think is which is some paramount importance. The leading force of this matter is predicated on facts and a profound complaint. Further complaints presented before Mr. Stevens made Stevens' failure to not accept the plea agreement in the state felony in the past, from what has happened. First, what may happen. Articulates the presiding judge. Decision years back in a state jail case. I guess it was in a forgery case. Is that right?
Recuse, yeah, that
Yeah, okay. Okay. Which I really can't read your.
I know.
Where premises considered prevalent that said judge step aside in the best interest of justice. And I, I don't understand your writing, because it's hard to write in there, but I don't understand what you are articulating that causes this, that would cause this court to step aside. It seems to state you just don't prefer me, and that's not enough, under law. But if you want to write some more, go ahead. But at this time, I don't find that the four corners of your pro se motion sets forth valid reasons for this court to step aside.
Okay.
So we're going to continue to move forward, and you want to continue to represent yourself.
Yes, sir.
All
I would
right.
like
And you want to go to trial.
Right. I would like copies of all that's been denied as well. And a copy of my indictment, copy of cause and information if at all possible, yeah.
Yeah, okay. If Reggie, can you make just a copy? As possible, at any time you want to change your mind, let me know immediately so we can get somebody in here, okay? Yes, sir. All right, sir.
Thank you.
All right, thank you. What else?
Judge, do you need him to fill out this anything now?
Yeah, he needs to do it now while we've got him here. Anything else?
No, Judge.
Is that it? All right. Who else do we have? All right, we now call cause number 22-39418, the state of Texas versus Charles Ray Moss III. That's you?
Yes, sir.
Present. Mr. Gertz is here representing you, and the state's counsel is here, Mr. Ham. Earlier in this case, you were indicted by a grand jury for the first degree felony of murder. You entered a plea of guilty to the lesser included second degree felony of manslaughter. And a pre-sentence report has been ordered. Have the parties had an opportunity to review the pre-sentence report? Any corrections or changes to it, state
None from the state, Judge.
or defense?
We have, Judge, and we do not have any changes or corrections.
Made a part of the record for all purposes. The agreement is a cap of 15 years, I believe, correct?
Yes, Judge.
So you are looking at no less than 2, nor more than 15 years confinement in prison. I don't believe regular probation is an option.
That's correct, Judge.
Deferred can be.
Yes, Judge.
And there are some things I highlighted here that I'd like the parties to address during this hearing, and the defendant may want to if he wishes. Okay. The Go ahead, state, if you want to go first, or you can go last.
I'd like to go last, Judge.
All right, defense, go ahead.
Judge, we're asking the court to consider deferred probation in this case for a couple of reasons. One is Mr. Moss is not even though he did engage in a fight with the decedent prior to the shooting, he is not the person who shot anyone. I don't think that's anyone's contention, but he was obviously a participant in this episode. Secondly, though, Judge, he has very limited criminal history. In fact, just has a possession of marijuana out of Smith County, but other than that, has little or no criminal history. And then, additionally, Judge, he's been in custody now. I want to say for almost 5 years, if not at 5 years, on this charge. And so, that's a significant amount of time under his belt, so to speak.
Well, this has occurred on February 17th, 2022.
Well,
The most he can have is 4 years.
4 years. Either way, he's been in custody since within a few days of the shooting, Judge. So I miscalculated that. I apologize to the court. But for 4 years, he's been in custody on this, and it seems to me it would be logical for the court to consider supervising him over the course of that 10 years of deferred adjudication and trying to help him get on the right track with his life and making better choices and things of that nature, as opposed to merely just giving him a prison sentence and letting that be the result. So we're asking the court to give consideration to that option, which again would, if he were to violate it, we've talked about it very thoroughly. If he were to violate his probation, he understands the severity of the consequences. He understands that the 15 years in the cap would go away, and instead he would be facing up to the full amount, which would be 20 years in this case, Judge.
Right, so I'm going to provide a little background so we can put this in perspective, Judge. There's 3 individuals that were charged with this offense. Specifically, Jacoby Broussard took a plea bargain agreement of a cap of 30 years to the murder offense. That was he was pled on October 6th of 2025. He came back on his sentencing on December 1st, and he received 30 years. It was at that time as well that we moved one of the other cases, Arthur Small, who in my opinion had less involvement than Mr. Moss. He received a plea for manslaughter and accepted a sentence of 8 years TDC, and that was subject to his testimony that was going to be offered against Mr. Broussard and Mr. Moss that directly contradicts what the defendant's version on page 1. Mr. Moss, we fashioned an agreement with him to allow him to plead to manslaughter as opposed to murder, again, because of not being the shooter at the time as far as the state's understanding of the evidence, but the fact that he was actively involved, participated in this, and again, specifically, what's highlighted on page 1 is that he was there, he observed it, and I know Your Honor's read the statements of the interested parties. The fact that someone could walk away from that and not do anything and then really stand here and ask you for probation is, I understand why they do, but it's just not warranted. When we look here at things from a perspective, the sentence that we gave Mr. Broussard was proper. The sentence that Mr. Small received is proper. It's appropriate that Mr. Moss receive a sentence somewhere between the 30 and the 8 years. To give him
Between what?
30 and 8. Mr. Small received an 8-year sentence. Mr. Broussard received a 30-year sentence. Mr. Moss can receive anywhere up to 15 years. And I'm just telling the court how I fashioned this agreement. There was a fourth individual that was immediately came forward and was not present at, not actively involved, and purposely identified all these individuals. And that's the reason why he went uncharged as far as these facts and circumstances are concerned. But to lessen the punishment for Mr. Moss would be highly inappropriate in this lawyer's opinion. I do agree that Mr. Moss has been in custody for the sum of approximately 4 years. I agree that he has a limited history involving this situation, but his lack really of accepting any kind of responsibility for this and a lack of remorse about what happened doesn't warrant the sentence that they're asking. I feel that 15 years is appropriate, Judge.
Okay. Go ahead. Anything you want to say?
No, Judge, I think,
Okay.
I think, my only disagreement with him is about the, what the outcome should be. I think that, you know, the court has an opportunity here to address this young man's challenges and issues. And, you know, if the court does see fit to give him 15 years, you know, theoretically, he would be eligible for parole in 3 years and, you know, would just be out versus being on the court's supervision for an extended period of time, a much more extended period of time, and all the while having the ability, as the court is well aware, to put him back in prison for an even further extended period of time based on his performance. So I'm asking the court to consider it. I understand what the sentences were for the other people involved, but I think the court can by its verdict can supervise this person, and by its ruling can supervise this person, and be as effective or even more effective than just a plain prison sentence.
One last thing I forgot to mention to Your Honor is when this was set on November 13th, it was on the trial docket. It was at that time that Mr. Moss learned that in addition to Small testifying against him, that Broussard was prepared to testify against him. So all the individuals there were about to come into the courtroom and set forth his actions. And it's only then, in my opinion, when his feet were on fire that we entered into this agreement. So we never fault somebody for waiting, but it is a fact that I wanted to share with the court.
Okay. I'm kind of funny about the presumption of innocence.
Yes, sir.
I did too, Judge.
I wrote an article on that one.
Yes, Judge.
And it's the lead article, by the way.
To be fair, I mean, we made decisions for a variety of reasons. Those people would have been subject to cross-examination, and we can see what we would have landed. But he's chosen to accept responsibility for his.
That's what this is all about.
Yes, Judge.
The circumstances of the crime, criminal history, those are the equations. Those are the factors that go into the equation of determining a sentence. You pleaded guilty not to the indictment of murder, but to the lesser included offense of manslaughter.
Yes, sir.
Okay. Did you want to say anything to the court?
No,
Because, okay, because there's a big gap problem here. The pre-sentence report is made a part of the record here without objection. I want to know what you did. Because I can't understand it. It's not clear at all. You admitted, you pleaded guilty under oath to recklessly causing the death of an individual. I don't want you to explain to me or anybody what you did to recklessly cause the death, because according to this pre-sentence report, you didn't do a thing, which doesn't amount to culpability. Anything you want to say? Or I thought you were complete. Go ahead.
Well, I'm gonna,
Anything else?
I'm always concerned about questions like that for my clients, but
Yeah.
I think the answer here is goes back to the rule of parties. So we make a calculation about pleading guilty, not just based on the
Okay,
language of
go
the
into the,
indictment.
tell me how that connects him. That he just wasn't in the same area code. What was his connection with the party?
Well, Judge, he started the fight or got involved in the fight that started this entire process. I mean, his decisions to participate in the fight that ultimately led to the death of the decedent, even though it was someone else who did the shooting, he was there and was an active participant. And so, again, that's what the eyewitness says. It's what the other people involved.
Where's the evidence in the history of the reports and all that show where the defendant was at the time of the death? Is there anything you can?
There's statements from Arthur Small from the beginning that he was involved as an individual that got out of the car when Jacoby Broussard shot. And that's also confirmed from the uncharged conspirator, Ladarius Stevenson. So all that's from the onset, Judge.
And the defendant has nothing more to say, right?
Yes, yes, that's it.
Okay. All right. Anything else?
No, Your Honor.
If not, your last chance, because I'm about to proceed with the rendering of punishment. Okay, it's your call.
I just want to say that I apologize for what happened.
Well, what happened?
The
That
deceased
you're
was my,
apologizing
the
for?
deceased was my best friend.
I know. What did you have to do with his death?
Nothing. That day I was called to go feed.
All right. All right. You just heard what he said. I had nothing to do with his death.
Judge, he is a party to this offense.
Sir, I know that. I know what he's saying, but how can he say, I plead guilty and I had nothing to do with it? Can you fix that in the record? Because it's a problem.
I understand, Judge. Again, this is why I try not to encourage my clients to have conversations with the court like this.
Well, but no, it's trying to place a square peg in a round hole. It's not fitting.
Judge, the answer again is he was actively involved in a fight with a person that was his friend, but ultimately was the decedent at the hands of another person, Mr. Broussard. And he was there. They were all at the stables. They were there. But when he says nothing, he means he wasn't the person that pulls out the gun and shot anybody. He didn't pull out the gun. He didn't produce the gun. He didn't hide the gun. Well, Judge, he was involved in the fight that led to the altercation that led to the decedent's death.
But I thought
Only
left
one
and
person
separated himself from that before the event.
I don't think it's before the event, Judge. I don't think that would not be the evidence at trial. And
that's not what he just said. That's not what this says. Shortly didn't. He had no idea who shot and killed him. Found out the next day. Interviewed. We got in a fight. However, he left shortly after and did not return. I mean, I'm not a dummy. I mean, this doesn't add up to being present at the time of the event. But he pleaded guilty. All right. Anything else?
No, Judge.
Anything else from anybody?
There you go.
All right. Here, Mr. Moss, you have pleaded guilty to this lesser included offense of the second degree of manslaughter voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of manslaughter. I am following this agreement You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. You understand what has happened today, sir?
Yes, sir.
You will be given credit for all time you have served in accordance with this place. Anything else to add by anybody?
No, yeah.
All right,
Thank you.
that is all.
So the first thing that I noticed is that Mr. Wood, is it Davis or Wood? Davis, your middle name?
Davis is my middle name.
Okay, so Mr. Wood, the address that you have listed here falls in precinct 5. Do you live on Ranch Creek Drive?
No, I live in Pflugerville.
You live in Pflugerville, so even more so. So the address in Pflugerville is on Town Center Drive, is that correct?
Yes.
Okay. Right there, because I think that may be the precinct, so it's,
Precinct 2.
okay. All right, so this is precinct 3, so it was filed in the wrong precinct, so that's the first issue that we need to address. That is to say that with the party's consent, we can hear it here, but it should be in precinct 2, not in this precinct. And so, Mr. Wood, you're the party here that has been sued. Ms. O'Hara, you're the one that filed it. Was there a reason, Ms. O'Hara, why you filed in precinct 3 and not in precinct 2?
Yes, the offense happened in precinct 3 while we both resided there at that time.
Alleged offense. Okay. Which alleged offense? Because you're not suing based on an alleged offense. You're claiming this is as a civil matter that he caused you harm. Okay. And you're saying, at least in the complaint, it says there's a false allegation that was made, a false police report that was made.
That is correct.
Okay,
That led
so
to an arrest.
that is the offense here that you're claiming, right? If in fact there was actual any type of assault, physical assault, according to your complaint, he filed the false allegation that you had committed the assault on him. Is that correct?
Correct.
But you're suing based on the false allegation.
I'm
So
suing on damages and a debt claim that's been unpaid.
So it doesn't say anything in here about a debt claim in your petition.
Yes, I made an amendment to the court. I emailed the court telling them that I needed to amend the original petition, and they accepted it, told me how to do it, and it was emailed back, and they accepted the amended petition. So it should say damages and a debt claim.
Okay, so there's a debt claim for unpaid dues. Okay.
Correct.
And then there's damage to property. Where did the damage to property occur?
Precinct 3.
And the debt that's owed,
Same precinct.
because it says for unpaid dues. Is this a membership of some sort?
No, this was a contract from a loan. It should say from unpaid loan. It was a loan that I loaned Mr. Wood, and he didn't fully pay back the loan. And we have it was a signed contract sent by him to me, docu-signed and signed by both of us.
For $4,000, which you were paid.
But that's okay. That's just an allegation that she's making at this stage. So you don't have to respond to that. All right. So let's take a look here. Okay. Any objection then to hearing the case here?
I'm sorry, could you repeat that? I didn't hear that.
Is there any objection on behalf of Mr. Wood for me hearing this case here, right?
I have no objection, Your Honor.
Okay, so we're gonna go forward then. So typically what I also like to do is I like to give people an opportunity to try and see if there's any chance for resolution. Do you think that there's a chance of resolution if I put you into a breakout room so the two of you can talk together to see if you can reach an agreement? Or do we need to go forward with this case?
I would be happy to enter into negotiations with the defendant.
Or is that something that you'd be open to doing here, let's say 5-10 minutes? See if we can reach an agreement.
I'm sorry, was that a question for me?
It was a question for Mr. Wood.
Okay.
Your Honor, I don't believe we have anything to discuss.
Okay, not a problem. If I can have both parties please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Yeah.
Your Honor.
All right. All right, Ms. O'Hara, this is your case. So I'll give you an opportunity, just a real brief 30 seconds, 1 minute tops, opening statement, please.
Okay, Your Honor, first off, I emailed the clerk to request the defendant's evidence, and she sent me an email back. And in communication this morning, she stated that she has also not received any of my evidence, and I submitted this on Friday. I'm really concerned about not being able to try a case with my witnesses because they won't be able to see the evidence.
Okay, so here's an issue. This case was specially set for today, okay? Any request for evidence needs to be done well enough in advance so that there's ample opportunity for the parties to exchange, to raise objections, to do any type of discovery, right? Because typically you have 30 days to respond to discovery prior to the court trial. This case has been specially set. So what that means is that if you have not sent that request to him specifically, right? Sending it to the court doesn't do anything because the court, he has to be notified of that. So if you have a motion that you filed, he has to be notified of that motion as well. Okay.
I sent it to the clerk, and the clerk sent it to the defendant.
Well, that's an assumption that we're making that was done, because it's certainly not a requirement on the clerk's part to send it to the defendant. It's your responsibility to do that. Okay. So when did you send the request for discovery to the defendant?
I sent the request to the clerk on Friday.
Friday is not sufficient enough time, so I'm going to deny that request. So if you wish to proceed, we're going to proceed without any of those requirements, because there simply was not enough time for any kind of response to be done in that time period, because he's entitled to 30 days.
And I don't necessarily need the defendant's evidence, but what my greater concern is that the court doesn't show that they have my evidence. And I have, I'll just show you the paper copies. This is how much evidence I submitted.
Okay. How did you submit it?
I submitted it by a scanner and emailed it to the court.
Okay. Did you scan everything into one document and send that one document to the court?
I scanned it and grouped it into, I believe the scanner did do it in one document, yes.
It's possible, and I'm not saying that this is in fact true, it's possible that that file was too large and it didn't go through.
Yeah, I also did it in separate ones. So I did it in duplicate, and I grouped it into, because I looked at the megabytes and made sure that I was under the megabytes there so that the file could send. And it was well under, each one was well under the megabytes.
Where is the email that you sent that attached that? In other words, when you said you did that on Friday, is that correct?
Yes.
Mary, do you have, no, we don't, because everything that I'm looking at here is dated. If you sent it on Friday, it's possible that it's still in a holding area. Is that possible?
If that's the case, do we need to reset this hearing so until the evidence comes in?
The reason I say that is because if you sent it on Friday, Mary, do you see it anywhere in holding? Perhaps?
No, I checked all of our inbox. I checked our archived everything. I do not see anything. I asked Ms. O'Hara to resubmit it to us while we were waiting. She said she was unable to. So unfortunately, I don't see that we ever received it.
So here's the thing. Because it was done on Friday, what time was it done, Ms. O'Hara, on Friday?
It was approximately lunchtime.
Lunchtime. What is your email address? Mary, can you look that up to see if there's,
Mhm. Yeah, I searched up with her email address and as well with her case number. I could not find anything, even in our junk, maybe went through there, could not find anything as well.
so unless you're able to present it now, Sahara, I can't consider any of that because it's, you have to be able to present it so that we can see it, right? And Mr.
Yes,
Wood be able
absolutely.
to-
So I can question my witnesses.
I would say
So
what-
as I understand it, this case was specially set today, which means that we did this on Zoom specifically for you all to have this hearing. Now, I can tell you from my experience here is that, in order to prove up your case, you're going to need evidence. And without physical evidence, it's going to be your word against his word. And Mr. Wood, I don't know if you have specific evidence, but that means you're going to have to show it, share your screen to be able to show what it is that you're talking about. This is not a court of record. So it's not like we're recording. Well, technically we are recording here because we're live on YouTube, but that will be deleted as soon as we're done here.
Well, Your Honor, I filed my response to this case. I don't know, over a year ago.
Yeah, I see the answer. And I think you filed a motion to dismiss as well. Is that correct?
Yes, Your Honor, this is nothing but continued harassment.
Well,
Just now it's being tied to a civil case for monetary damages that are not owed.
has there ever been a hearing on the civil case?
This is
Sorry, on the motion to dismiss.
I sent it in. All I ever got back was that it was reset. So I never heard a ruling on my motion to dismiss.
Judge Olivo, we did send it to our Judge Holmes for review. She stated that the case just may be set for a TBC and proceed as normal. That's what the note stated.
So, but she never heard the motion to dismiss. Is that right?
Yeah, it says no action needed by court on this defendant's motion to dismiss.
All right. So we basically ruled on that.
It was Judge Holmes.
Yeah, that's what I'm saying. Judge Holmes ruled on it already, basically, that in essence, she's denying the motion to dismiss.
Yes, essentially.
Okay.
And Judge Olivo, just as I could, Ms. can share her screen if she has the documents on her phone, to see if she can do that as well.
Say that again, it kind of cut out, sorry.
Ms. O'Hara can share her screen with the evidence if she has it on her phone or like the device she's
it's all on paper.
Yeah.
But the scan, she said you scanned it.
Yes.
That scan.
I tried to get the evidence from the scan so I could share it on the screen during the break while we were waiting, and I wasn't successful so far.
Unless that scan is actually saved on her phone, she won't be able to go to the phone to open it. So she would have to like put the camera on it in order to see it and hold on to it. All right. As I mentioned to the case before this one, I do not like pushing these cases down, but I can tell you that the only evidence I'm going to be considering today is the evidence that is presented orally and that which is already in our system that we've already received. I cannot consider anything else because we don't have anything else to consider.
Your Honor, would we be able to do a motion for continuance because of this, because you guys did not receive my evidence? Because it's very important because I can show that on many occasions that the defendant is lying and will lie.
I want to clarify also, the motion for continuance is not based on we didn't receive it, right? Because if it was sent, we would have received it. So the motion for continuance would be based on some error on your side, not getting it here. And then because each side, generally, we're going to grant a continuance. And it looks like Mr. Wood requested a continuance in the past, and we granted that. Actually, each of the parties have requested a continuance in the past.
Yes.
All right. So I don't know the basis of that, other than that both of you have requested it. So if you're both in agreement to continue this case, it's gonna have to be specially set again, and it's gonna be down the road. It's gonna be at least 2 months down the road. It's not gonna be next week.
Okay.
Your
And
Honor, I'd like
I'd
to
be
get,
willing to see this in precinct 2. I'd be more than happy to do that in precinct 2 where he lives currently.
Then you'll have to file a motion to change venue. To put it back into the precinct where he lives.
Okay, is that what we would need to do is, would I need to do that to file a motion, to change venue?
Either one of you can do that.
Okay.
Your
Okay.
Honor, I would just assume to have this case ruled on now. I don't have time to go through her hundreds of pages of whatever it is.
You're opposed to the continuance at this point.
I'm opposed to the continuance. I had to take a day off of work. I'm tired of this hanging over me. It's just yet one more form of harassment.
Mary, tell me about the setting on this, because as I understand it, what's specially set. So we went out of our way to set this specifically today. Is that correct?
Yes.
Y'all picked the date.
No. Well, that's why I'm asking the clerk, is because she has notes as to the history on why this case was set today specifically. In other words, we can take any date, right? But you're appearing, both of you are appearing by Zoom. You're not here in person. So we went out of our way to make these accommodations for the parties today. And so
Yes.
that's what I'm trying to find out. What's the basis for that? And so Mary, the court clerk, is telling me that it was specially set, which means that if there's an objection to a continuance, then I have to take that into consideration.
Well, Your Honor, the reason I did not want to do this is I have no desire to be in the same room with Ms. Guerra. All this results from yet another physical assault by her on me.
Okay.
It's taken me thousands of dollars of therapy.
Sir,
I don't want to be with her.
Mr. Wood, I'm going to give you an opportunity. All right, so this is what we're going to do. We're going to go forward. I'm going to deny any type of continuance. We're not going to be, I'm going to deny any requirement for any discovery at this point in time. We're going to move forward. I've already sworn each of the parties in. Ms. O'Hara, as I asked previously, give me a quick 30-second to 60-second introduction. Just why are you here? Why are you demanding that Mr. Wood owes you money? And then we'll move on to him.
Okay, thank you, Your Honor. Yes, we are here because there was a false accusation made that led to a dismissal. The court record states insufficient evidence, upside down case. That rendered me suddenly homeless. And all this occurred right after I had Achilles tendon surgery, was not able to walk, was not weight bearing. I incurred extensive amount of debt, attorneys, hotel fees, emergency housing fees. My insurance, we were on the same insurance policy. Without notice, that was suddenly cut. And I was in the process of extensive physical therapy 3 times a week. So I had to pay that out of pocket. I had multiple, I wasn't able to drive because it's my right foot. And I had to obtain Lyft rides in order to get to physical therapy. 2 physical therapy appointments were canceled, which I was charged for. My knee scooter was also taken when I was arrested, and I was not able to walk. Therefore, I had to go to the hospital right after. I'm not asking for that, but there are medical expenses due to the fact that I had to pay them out of pocket that were already, the appointments were already set prior to the false accusation. And also there was a contract debt that was not fully paid back with the interest fees that Mr. Wood stated in the contract. And in Mr. Wood's response to the court, I can prove that all 4 of those points are fallacies, lies with my evidence. And also Mr. Wood filed a continuance. We had a hearing set for December 9th, which I also took that day off. Mr. Wood stated that his reasons for continuance said he was out of town for his daughter's graduation. I have facts showing that he was actually in Austin, Texas at work on Ranch Creek. He was working, he was in town. His daughter didn't graduate till Saturday, and he had not left town yet. So he could have gone to that hearing on December 9th, and I took that day off as well as today.
Issue of the continuance on the hearing has no bearing on this case whatsoever. And so I'm not going to hear any evidence with respect to that.
I understand.
Because we're here just simply because you're claiming that you've suffered damages as a result of Mr. Wood's actions. Okay, so that's it. That's what we're here for today. Okay.
Thank you.
All right, Mr. Wood, real quick brief, 30 seconds to a minute. Opening statement, please.
Your Honor, in the incident that happened on February 20th, 24, the decision to arrest Miss O'Hara was not made by me. It was made by the Travis County Sheriff's Department. They took pictures of the handprint on my face, the whole 9 yards. This was not the first time I was assaulted by Miss O'Hara. It was just the straw that broke the camel's back. The Travis County CA advised me to leave, claiming domestic abuse. I had to rearrange my life, terminate my lease, establish a new lease. I handled all the moving expenses. I've even paid for 6 months of storage on Miss O'Hara's storage unit and that was based on her breaking in and stealing things out of the storage unit that I had by cutting the locks off of them, which is documented in another Travis County Sheriff's investigation. I just want to move on with my life. I'm not seeking any damages against Miss O'Hara. I just want her out of my life and to move on with hers. It has been 2 years. The continual harassment, I have been signed up for everything from Tinder to Grindr to, just little annoyances, calls to my work. I just need it to stop, and I just would like for her to go away and live her life. Let me leave mine.
Just to kind of give you both a little bit of understanding of the general rules of civil procedure don't apply in this court like they normally do in other courts. So with that said, I'm going to give some leeway in terms of evidence that's presented. You still need to object. If you object to a particular thing, I will rule on those objections, make sure that if somebody makes an objection, you allow me to respond to that objection before you continue giving evidence or talking or testifying, okay? With that said, I will be, in order to move this case along, and not to get into any tangents, I'm going to be asking some questions of each of the parties to kind of guide you in a sense. I'm not going to be helping you, but it's based questions that were based on things that I need to know from assumptions that I'll be making from the petition, from the answer on where it is I believe that you're trying to take your claims. Okay. All right. With that said, Ms. O'Hara, you may begin.
Yes, 1 moment here. Okay, my apologies. Yes, in regards to, first off, I have a motion to dismiss that was accepted, upside down case.
Okay.
File stamped by the court. I also have, in regards to Mr. Wood's claim about paying for storage, that's not true. Oh, I'm sorry. Go ahead, sir.
Are you asking that that document be entered into evidence?
Yeah, that's what I sent in, or yes, I apologize. Yes, that's what I submitted in the scanned documents. How would I do that now?
So if you'll put that document back up again, just kind of hold it there. Mr. Wood, if you want to take a look at that, it says motion to dismiss, and it's the county attorney has signed that to dismiss the assault family violence charge. See that?
I actually cannot see it, Your Honor, but
You can.
I find it,
maybe.
Let me see, it's got a bar across it on my screen. I cannot read that, it's way too small. Your
I could
Honor,
try to put a spotlight and see if that works.
I was never informed about the hearing date because I would have gone to that hearing. And I was never even given a chance to tell my side of the story during that procedure.
Objection, incorrect.
So your objection is overruled. So Ms. O'Hara, you're presenting a document saying that the case was dismissed, and you're also making allegations that it was dismissed because it was false. That's not true either, okay? The only basis for that document being entered into evidence is to prove that in fact the case was dismissed. That's it, nothing else. There's nothing about this document that would suggest why it was dismissed or who chose to dismiss it, under what circumstances, whether Mr. Wood was consulted with it beforehand or not. The only thing this document does is provide evidence that the case in fact was dismissed. That's it.
Yes, it states the reason as well.
Yeah, but that has nothing to do with anything here. It just means that the case was dismissed. So, Mr. Wood, is there any objection to this document simply that the case was dismissed? That's the only thing that I'm considering that document for.
I object to it simply because I was never informed of that case when that case went to trial. I was never even given a chance to do it.
All right, so I'm overrule that objection. Again, you being advised of it is not the question that I'm asking. I'm asking, do you object to the document itself that it states that the case was dismissed? We're not talking about why it was dismissed, how it was dismissed. The only thing is that it states that the case was dismissed. That's it. That's the only thing I'm considering about that document.
I guess I will accept it, Your Honor.
I'm going to accept it, and Ms. O'Hara, make sure you make a note that document needs to be sent in. Now, my question to you, Ms. O'Hara, what does that document have to do anything to do with this case?
It's one piece of evidence showing that it was dismissed, cannot be proved beyond a reasonable doubt, case is upside down. And the DA dismissed it, not my attorney.
Again, what does Mr. Wood filing these charges against you have to do with your damages?
These charges basically is why I incurred over $20,000 of debt.
So if you incurred more than $20,000 in debt.
Yes, I'm only asking for $19,500 though.
Okay, but you don't get to say, I incurred more than 20,000, but I'm only asking for 19,000. Therefore, it falls in the jurisdictional limits of the court. If you incurred more than $20,000 in debt, this case needs to go to a different court and we don't have jurisdiction. It's as simple as that.
Okay.
It's not what you're asking for. It's what the damages that were caused that determines whether we have jurisdiction or not.
Which court would this need to go to?
We would go to the county court of law or the district court. But we would not come here because we have a.
Okay, but would I requesting your information, but would I would this case still, because it was filed, would it still fall under the statute of limitations?
I don't know when this happened. There's a 4-year statute of limitations when it comes to injuries. Okay.
Okay.
Some type of personal injury. I don't know that that's what you're claiming here because your petition is not clear. This is not a breach of contract. Now, you do have a breach of contract issue because in your amended petition, you filed the issue of a debt. Okay?
Yes.
And so that is a breach of contract. That's a 2-year statute of limitation.
Okay. And when I filed this, and part of the reason I chose to do small claims is I didn't want a lengthy litigation And the documents that I have here show the debt of under 20,000.
What was the debt incurred?
The debt incurred are medical fees, counseling fees, hotel fees for housing.
Hold on. You claimed earlier that there is a loan that you gave him that he owes you for.
Correct. A $4,000 loan, he paid half without the fees and the interest.
When was that loan entered into?
That loan was entered into, let me get my evidence here. One moment. May 5th, 2021. And the statute of limitations on debt claim is 4 years.
No, that's not correct. Statute of limitations on this is 2 years on a loan that you've given to him, because that's a breach of contract. And when did you file this case?
I filed this case February of 2025.
Yeah, so that's more than the 2 years. And so any claims that you have with respect to an unpaid loan are hereby dismissed because it does not meet the statute of limitations. So we're not going to talk about any of that whatsoever. Okay, let's talk about when did the injury occur that you received that caused you to spend all this additional money because of
February
your
26th, 2024.
2024.
Correct.
All right. So you're still within the 2-year statute of limitation if it falls into that. I'm still not convinced that this is a personal injury type of case because you're claiming damages, but you're not claiming the damages from him assaulting you. You're claiming that because of his allegation of the assault against you and you were arrested, that's what in fact caused you to lose your home, to incur medical fees and all that. Is that correct?
Yes, as well as he took my knee scooter from jail and I wasn't able to walk. So I fell about 10 steps outside of the jail after being released.
I think you walked through the jail.
I'm sorry?
Well, you were in the jail for how long?
6 days.
6 days. How did you walk without that scooter?
I didn't. I was non-weight bearing. They brought me a wheelchair. Once they brought me inside, they issued me a wheelchair and allowed it to stay in my room.
And
I was
then
not able to walk.
Did they walk you down to the door?
I wasn't able to walk. They came in and asked me if I was able to walk unassisted, and I said no. And I asked them if they had if I could use the wheelchair or a walker or something, and they said no.
Just to be clear, Ms. O'Hara, you're going to have to show approximate cause between your injuries and his actions, okay? And the fact that he did not, or that he picked up that little scooter, that did not cause your injury when you fell down 10 steps later, okay? I'm just going to tell you that right now. If he pushed you, or if he took it away from you while you had it, then that's approximate cause, okay? But when you took those 10 steps without it, you did that of your own accord. There is not an issue here of proximate cause that because he picked up that little knee scooter, therefore you fell down and that's where you suffered an injury.
Your Honor, may I speak?
No, sir. All right, Ms. O'Hara. Let me go back a step so I can better understand it. Were you all in a relationship?
Yes, we were, and in the end, we were just
Were you living
roommates.
together?
I'm sorry?
Were you living together?
Yes.
Okay. Did this breakup result in you leaving, Ms. O'Hara?
No, the breakup, because there was a prior accusation made by Mr. Wood that was also declined. The charges were I was never charged on that. It needed to be expunged. And Mr. Wood said I
what
could
you were asking.
rent an apartment.
Okay, when did you all split up?
February 20, we broke up the relationship as a boyfriend-girlfriend relationship in September of 2023.
Okay, and the allegation, so what caused you all to be together again in February of 2025? Or
My
2025?
case in Hayes County from his accusation, he was strangling me, so I did bite him in self-defense to get away. Was not finalized yet.
So hold on, you said Hayes County.
Correct.
So all of this happened in Hayes County?
No. There was one incident. I had COVID. I was hypoxic, meaning low oxygen. And Mr. Wood was very combative. He put me in a chokehold headlock. I bit his arm to get out for self-defense, asked him to leave the apartment, which he did.
What does that have to do with you losing your home and having to go into the Safe Alliance and incurring medical injuries because of your foot when you were in jail? What do those things have to do with that?
I wasn't going to bring it up in this case. Mr. Wood did in emailing to the court.
Okay, so the Hayes County case has nothing to do with it.
I don't believe it does, no.
Okay, then we don't need to speak about that. So let's
Okay.
move forward to then the case that you're claiming where he made the false allegation. That was in February of 24, is that correct?
Correct.
Okay. According to you, he makes a false allegation and you get arrested that day, is that correct?
Yes, and I can provide a motive that he wanted to get out of the apartment lease without penalties.
Okay, that motive has nothing to do with this case.
Okay.
So, all right. So you get arrested that day in February 2024.
Correct.
You're in jail for 6 days.
Correct.
And that's here in Travis County.
Yes, sir.
Okay. When you get out of jail, you fall down and injure your foot.
I'm not, those aren't the injuries that the medical expenses that I'm requesting. I'm requesting medical expenses for missed physical therapy appointments and suddenly having out of pocket, having to pay for physical therapy 3 times a week, plus the 2 missed appointments.
He caused you to miss those appointments.
Because he made the false accusation that led to an arrest.
Okay, so were you in jail and that's why you missed those appointments?
Correct, Your Honor.
So you missed multiple physical therapy appointments and you missed other doctor's appointments all in that 6-day period.
Yes, sir.
All right. Tell me more about your case.
Okay. I was in touch with I had Achilles tendon surgery right around New Year's of 2024, a month and a half prior. During this time, oh, I'm sorry.
Did the Achilles tendon surgery have anything to do with Mr. Wood, or that's just something that you had done separately?
Yes, there was abuse was becoming abundant by Mr. Wood, such as neglect, such as he filed me on his IRS taxes against my consent, or knowledge.
So Harry, we're getting off on the tangents here.
Financial abuse.
Did Mr. Wood have anything to do with you having to have the tendon surgery?
No.
Okay. All right. So I don't need to hear about all those other things.
Okay.
All right. So you had tendon surgery. Okay. And that's the reason that you had foot problems. Right?
I'm not sure that I understand your wording. Could you repeat that?
So you had the Achilles tendon surgery for some reason other than anything to do with Mr. Wood.
Correct.
All right. You had that surgery done when?
December 28th, 2023, to be exact.
Okay, but it was in 25 when you had this, when you got arrested.
No, 24. So it was approximately 2 months,
Late.
2
Okay.
months after surgery.
Okay, so 2 months after surgery, so you're still doing rehab on that? Okay. You
Starting,
get arrested, so therefore you can't go to some of your appointments.
correct.
All right. Now you claim that that you're no longer on his insurance and you had to pay out of pocket.
Yes, and I was not informed of that at all. I found that out by going to
Were
the,
you married?
I'm sorry?
Were you married to Mr. Wood?
No, I was not, but he claimed that I was on the lease agreement and other areas to other, he claimed to people in public that I was his wife. He identified me as Mr. Wood on his lease to the leasing agent or Marsha Wood. My name has never been Marsha Wood.
What obligation did he have to provide insurance to you?
He didn't. It was an agreement. It was actually an offer that he wanted so that I would sign him onto my lease at my first apartment.
Are you all living together? Because you told me you were not living together.
We were living together in Austin and many years ago, and he said that if you will let me live with you, I will claim you as a dependent on my insurance.
And at this time, when you got arrested, were you living with him?
Yes, I was.
Okay, so you all, because I asked you specifically if you were living together, and you said you were not.
I apologize, incorrect. We were living together.
So in February of 24, you were living together.
Yes, as roommates.
Okay. But as roommates, or were you having a relationship?
As roommates at that time, we broke up our romantic relationship September of 2023.
Okay. All right. All right, you make your solution.
Okay, me?
Yes, ma'am.
Okay, I just wanted to be clear. Okay, I have some witnesses to question that are waiting in the queue.
And what witness is going to testify about?
I'm sorry?
What are the witnesses going to testify about?
The witnesses are going to testify. Mr. Wood reached out to one witness, a licensed professional counselor of mine, attempting to create a narrative and her notes that have not been altered since the date of that. Then he was also threatening to call 911 because he knew I had a prior arrest.
What does this witness contribute to him owing you damages?
This witness contributes by showing manipulation and abuse prior to the arrest.
But you're not suing him because he manipulated you and abused you. You're
Yes,
suing
that
him,
is why I'm suing him.
but that's not what it says on your petition, and that's not clear. What you're suing him for is you're saying that because of his actions of filing a false police report and that you having to go to jail, that therefore you incurred expenses as a result of that.
Yes.
That's what you're saying.
And prior to the arrest, expenses with I need to hire a tax attorney to straighten it out because of the federal tampering of that's not the correct word, but claiming me on IRS, taking my social security card, which I've never provided to him. And that I've incurred costs for that
Did you hire a tax attorney?
Yes, I hired a friend that's a tax attorney. Yes.
And did they represent you to have your taxes redone?
Yes.
So did you pay someone to refile your tax return?
Yes, I did.
All right, make your seat then.
Okay. I have evidence showing that Mr. Wood is actually the hostile one. There's a police report that he was aggressive with his son, broke his son's phone. There's another police report.
Those things have nothing to do with your claim. So
All right.
I don't want to hear those things.
Okay, on the scan, I had multiple missed appointments and cost incurred. I went to counseling through a licensed professional counselor at $120 a counseling session once per week due to I was diagnosed with post-traumatic stress syndrome disorder.
One moment. Were you seeing a counselor prior to your arrest?
I was seeing a career counselor prior to my arrest.
And you went to a different counselor afterward?
No, same counselor.
Okay. How long have you been visiting that counselor prior to your arrest?
I was visiting her with her approximately 2020.
You said this is a career counselor. What does a career counselor
She
do?
changed to a career counselor. She's a licensed professional counselor.
Okay, is she the one that you have in the queue?
Yes.
Okay, let's go ahead and bring her in.
Okay.
So Mary, if you can bring her in, please.
Your Honor, can I object to this?
What is the objection?
What bearing does this have on this case?
Well, that's what we're going to find out. So if you can state unequivocally that it has absolutely no relevance whatsoever, then show me how. Otherwise, I'm going to ask the counselor so that I can get an idea of what kind of testimony they're going to present before I even allow the testimony. So, Ms. Williams, are you the counselor that she was talking about? You've been in here the whole time?
Yes.
Okay, let me have you raise your right hand, please. You solemnly swear the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, I'm going to ask you a few questions just to kind of get to where we're at. I do not want you to give me any type of privileged information of any sort. Okay, I'm just trying to find out, first of all, what kind of counselor are you?
Yeah, I'm a licensed professional counselor. I'm qualified for general counseling and I specialize in career counseling.
Okay, especially career. And so what does career counseling entail?
In my case, it's a very holistic approach to just all the roles in one's life and helping them work together to be the most purpose-oriented aspect of your life.
What type of education have you had to get you to this point to be a licensed professional counselor?
Yeah, I have a master's in counseling.
I'm assuming a bachelor's in
Psychology.
psychology. Okay, how long have you been doing this?
I got my license in 2013.
Now, with respect to Ms. O'Hara, I don't want you to give me any privileged information, but simply, let's start with, when did you first start seeing her as a client?
With the first counseling center, because I've moved several times, that goes back to, I think, 2015.
And you indicated that you specialize in career counseling. Were you giving career type advice to Ms. O'Hara? Is that what you were counseling her on?
That's one of the areas that we were working on, yes.
Okay. Were you working on other areas? What other areas were you working on?
Her general mental health, anxiety, and dealing with the stressors in her circumstances.
And these are things that have been going on since 2015, that you've been doing that type of counseling as early as 2015.
Yes, and the issues that she would work through have changed over time.
Okay.
Well, some have accumulated.
All right. Now, you've seen her regularly from 2015 until the period in time she was arrested. Is that correct?
Yes.
And so when she was arrested, that was in February of 2024. Is that correct?
That's my understanding, yes.
Did she miss an appointment with you during that 1 week? Okay, so she didn't incur any additional costs with respect to missing an appointment?
No.
Okay, now since that date, have her visits to you been similar to the type of counseling sessions that you had with her prior to that arrest?
This is the nature of symptoms, yes.
How often do you see her?
Usually once a week.
Once a week, and you've been seeing her once a week pretty much this entire time?
Mm-hmm.
Okay.
Yeah, brief hiatuses, but that's, I was on maternity leave once, yeah.
Do you receive insurance? We accept insurance payments.
No.
So everything is paid in cash.
Yes.
Okay. Thank you very much.
Yeah.
Ms. O'Hara, this witness is not going to provide any information that is relevant to your claims that he caused you these damages. Okay, so I'm not going to take evidence from this witness for that purpose in terms of any of those other types of claims. Okay.
Your Honor,
Yes, ma'am.
this witness can prove manipulation because this witness directly contacted this witness and manipulated and presented a narrative and manipulated her into trying to believe something that was not occurring.
So you're telling me that Mr. Wood manipulated your counselor into doing something that she would not otherwise do?
Correct. I left the apartment after
Well,
he
hold
was
on.
hostile and he was.
Miss O'Hara, you have to stop. Miss Williams, did Mr. Wood contact you and manipulate you into acting in a way that you otherwise would not have acted?
I wasn't manipulated into action. I did experience an attempt to manipulate me.
Okay, but you didn't do anything as a result of it?
No.
Okay, all right.
Well, Your Honor, she called me.
Miss Williams, you are free to go.
Okay.
You don't have, I mean, you can stick around if you want, but your services are no longer required.
Okay.
All right, Miss O'Hara, I need you to get to the point because you have not presented anything at all that would suggest that Mr. Wood is the cause for you having to spend additional monies for treatment to your foot or for anything else.
I also incurred expenses for movers. The initial down payment was $99. And that's the paper I have. In the scanned document, it was approximately $500 due to the fact that when I was at the storage unit separating my things, and by the way, we both had consent to enter that unit. And both of our names were on it. I was moving my things and separating them to my own unit. Mr. Wood showed up. There was a 30-day protective order. I advised him we're not allowed to be 250 yards from each other. Please step away. He did not. I was pinned in a corner. He was very hostile, yelling and screaming. So therefore, the movers were there for a lot longer. And so my total bill was approximately $600 combined with the down payment and the length of time they had to stay.
You all shared a rental unit, right? We're talking about storage unit. Is that what you're talking about? Or is this?
Correct. And also the storage unit waived 6 months. Mr. Wood did not pay for the 6 months of storing my items. He is lying about that.
Were his items in the storage unit?
Both of our items were in the storage unit.
And was he required to pay the full rent on the storage unit?
We were both paying it.
Okay, so you're saying he didn't pay his share? You paid yours?
The unit was, he was the primary under the unit, and I was allowed access. And I was listed under allowed access, but I was not on the lease.
You didn't pay any rent on the unit?
I paid him.
You paid him, not liable to pay any. So what have you lost?
What I lost was the moving expenses and having to get a separate one. And
I don't mean to belabor this point, but you guys don't have a relationship. You have a unit that he's responsible for paying, that you're paying half, right? And now you all have broken up and you want him to pay for you to move your things out. Show me where he's obligated to do that.
I would not have had to hire movers had he not made a false accusation.
The false accusation, man, has nothing to do with anything. He made an accusation, right, that you assaulted him. I'm not here to decide whether it was false or not false. The assistant county attorney signed a document saying that they didn't feel that they could prove the case. It doesn't mean that the statement was false. It just means that they didn't feel they could prove it. Okay? So that accusation is not the basis of you having to hire movers. I need you to present to me evidence that his specific actions are the direct cause of your damages. That's what I need to see. That's what I need to hear.
Okay. I went to my doctor's office and was diagnosed with PTSD. I paid that out of pocket. I paid $120 each week for counseling because I was struggling with nightmares, night terrors, post-traumatic stress disorder, anxiety.
All of those things, ma'am. Because for now, as far as I'm concerned, you're suffering those things, perhaps because of the arrest and having to spend the 6 days. And I can only imagine that that's a very difficult thing to do. But how is it that he's the cause of your PTSD?
Because I spent 6 days in jail on a false accusation. My dog was taken from me. My Pembroke Welsh Corgi was taken from me by Mr. Wood, and I am the sole owner of this Pembroke Welsh Corgi. And Mr. Wood was attempting to rehome my dog. I had to file a police report in order to get my dog back.
And I'm sorry to hear that, because I understand how pets are very important to people, and how for emotional support or any number of things on how,
Thank you.
I get that. I understand. And that can be difficult. But with all due respect, ma'am, you don't have a case here. This is a breakup gone bad, and you're blaming him for it. And you're upset that he filed charges against you. And I can tell you, I've been a judge for more than 20 years, and I've been a criminal defense attorney for longer than that. And I can tell you that of the more than 2,000 family violence cases that I've defended, okay, that the vast majority of them had some false allegations in them, okay? But even so, it comes down to a number of different issues. The two of you just simply don't get along. And after your breakup, you clearly should not have been living together, even as roommates, but you chose to.
No, and I wouldn't have. I was only living with him until my other case was eligible for expungement and dismissed in Hayes County. That is the only reason why, because I was not able to rent an apartment. I was staying in an extended stay.
No, and I understand that, but if you had an emergency protective order, you shouldn't have been living with him anyways.
We were not. That was after the arrest.
So you opted to live with him after those issues had occurred.
No, incorrect. There was a 30-day protective order issued after the arrest, February of 24.
And that expired, and then did you move in together again after that?
No, absolutely not. No, I'm in a much better place not being around that man.
And I'm sorry, I don't see any circumstance here, any situation where of your damages.
Would this make a difference? I had to liquidate my 401k with Charles Schwab in order to pay for the new expenses, the unexpected expenses of hotel and other lodging and healthcare. That was totally unnecessary. I had to liquidate my 401k for this.
You did not get along. He filed a criminal complaint against you. The police department, sheriff's department, whoever decided came in, for them it was sufficient to say this is enough to effectuate the arrest. Okay. You were not in a good place. You should not have been together in the first place. Okay.
No.
You're already broken up. You already were not getting along. You already had prior history. You opted to stay there, right? Up until the arrest, right?
Because he threatened that if I did not stay with him, that he would change his story with Hayes County, and then I would then be charged with the
expenses, okay, are expenses that you incurred because the relationship didn't work out.
The expenses incurred was because of his lie of a false accusation.
Well, let's assume for a second it was a lie, okay? The sheriff's department believed enough evidence existed at the time to arrest you, even if it was a lie.
I was very calm when they came. There was no physical contact or yelling between Mr. Wood and I that day. And I had 3 recused in the apartment that proved this.
Ma'am,
And
I'm asking you to provide to me something independent of Mr. Wood's actions that caused you to suffer this harm. And you're saying that because he lied about the physical
I have
assault.
hotel expenses.
Stop, because you're saying because he lied about it, that therefore you were arrested, and because you were arrested, you missed a number of appointments, physical therapy appointments. Okay?
Yes, I had to obtain emergency.
Stop. Missing those physical therapy appointments did, in and of itself, did not cause you to pay any additional fees. You fell when you walked out because you didn't have your little scooter for your leg.
Yeah, that doesn't matter.
Right. And again, there's no tie, there's no nexus between his actions and the cost that you incurred, right?
Incorrect, because I had to get emergency lodging, which was approximately $3,300 a month at extended stay hotels.
How much were you paying for rent?
The rent for the apartment was $1,700.
You were splitting that, or
Yeah.
you were paying $1,700?
We were splitting it.
Okay, so you needed to go find another apartment. Your claim is that you couldn't find another apartment because the expungement hearing had not occurred yet on the original case that you had with him.
That's what he told me, is that I wasn't able to rent a car, an apartment, or get
So
a
he
job.
told you couldn't.
Yes.
Did you try
And-
to rent an apartment?
Yes.
And why were you denied? The
Because
ability to
I had an arrest with 2 felony counts and a misdemeanor
Okay,
in Hayes County.
all right. Ma'am, I'm going to dismiss your case. There's no evidence here whatsoever to show that Mr. Wood is responsible.
What
for-
about the hotel fees and suddenly having to get in a mailbox because I was homeless due to his actions
Ma'am,
without warning?
All of these things have to do with a bad breakup. And because of the prior history that you all had, the physical history that you all had in Hayes County and in Travis County, enough so that you didn't have a relationship anymore, but you were still living together. So these are all things that you did knowingly go into a living situation with him.
I didn't have anywhere else to go. I stayed in an extended stay, and Mr. Wood begged me to.
Was the lease in your name? Was the lease in your name?
No, the lease was in his name, but I was the lease apartment leasing
you
agent
were
was
living
aware
there.
that I was there.
Right, and that's fine, but it wasn't in your name. You weren't liable on the lease. If he didn't pay, they weren't going to come after you. They were going to go after him.
Correct.
Right. Okay. You would have had to pay rent anywhere, regardless.
Correct.
Right. The fact that you chose to go to a hotel or someplace else, I get temporarily, but
That was the only place that I could rent.
Okay. I'm sorry, ma'am. There is no evidence, none, not a scintilla of evidence to suggest that he's responsible for these injuries or these damages you claim to have incurred as a result of him making allegations against you. There's no.
What
nexus-
about the out-of-pocket physical therapy fees, the out-of-pocket for Lyft rides because I no longer could get to physical therapy? The
I
out-of-pocket.
did physical therapy before. You said because it was your foot, it was the right foot.
Yes, actually, both of my feet are damaged.
You
I was supposed to have
to
surgery on
take
both.
them anyways, right? Because you had the surgery 2 months before all of this happened. How were
Yeah.
you getting through those appointments prior to you being arrested?
Mr. Wood agreed prior to the surgery to drive me.
And so now he's not driving you because you guys don't get along
No,
anymore.
he wasn't driving me towards the end. It was neglect.
So he wasn't. So how are you getting to those appointments towards the end?
I wasn't. I was trying to get Lyft rides. I was trying to get people in the community to help. I
No, ma'am.
wasn't.
No, ma'am, that's on you. You can't tell me that he caused you to miss appointments because he didn't want to take you because you guys aren't getting along.
The appointments that were missed that I'm referring to are after when I was arrested.
Right. But you also just told me that towards the end, he was neglecting you and he was not taking you to your appointments.
There was neglect in many forms, actually.
But you're not obligated to take you to these appointments, right? You're not married. There's not a relationship here anymore. You live together. He
But
was
we had
doing
an
it.
agreement prior to surgery.
And what did you do in return for the agreement?
In return, I kept the house. Did his laundry. I cooked all the meals. I did the grocery shopping.
That's not a contract, man. So there's not an agreement there. There's no consideration for him to take you to these appointments that he's required to do so. But there's nothing, you have no claim here, ma'am. I'm sorry. You simply do not have any claims here. Now, I understand how difficult this is for you. I understand that emotionally you've suffered through this, but you had a bad relationship to begin with and you opted to stay in it.
Well,
right?
I just thought of something else. I forgot. I apologize. I do have some damages because on the first arrest, Mr. Wood was not on my lease. I actually had another person on the lease because I did not want Mr. Wood living with me. We both contracted COVID for my daughter because Mr. Wood lied to the police officer, and also because I bit him in self-defense. I was arrested, and there's a fees involved in breaking that lease.
You're talking about the Hays County issue.
Yes.
And we've already agreed that I'm not going to hear anything to do with Hays County.
Okay.
Right. So that has no relevance here today. I'm dismissing this case. You just simply don't have a claim. All right. Good luck to you all.
Thank you, Your Honor.
Thank you, Your Honor.
I'm dismissing your case. You simply have nothing, not a scintilla, nothing at all. Ladies and gentlemen, oh my dear Lord, what cases? And I was actually watching that with y'all last night in Hutches and forgot all about that's where we saw it together and got excited. I'm embarrassed about that, but hey, I wanted to talk about that with you guys too. I mean, the secondhand embarrassment from the last case cannot be understated, no matter how many times we've seen it. And I think that may be my third time seeing it this week. That was a crazy case. And the Stevens segment before it, let's just say President's Day was a heck of a day for Judge Stevens. Wow. Ladies and gentlemen, I am your lone wolf Usul. I am your humble host for these here get-togethers, and I am your curator for these here compilation videos, and that's a little shaved puppy back there. I want to say thank you very much to all of our friends that supported the channel today. Give me just a second if I can do the little thing and shake my head just right. Face all the right directions. EXP Range, Great Granny, Wendy Michelle, Great Granny, twice over. What can I say? I'm humbled. I thank you very much. The puppies, thank you. The cat doesn't thank anybody, but he is happy to have you all serve him, just like any great cat would be. And I am going to say thank you, and I hope to see you again. I will be back during the week, same wolf time, same wolf channel, and keep an eye out for any videos that may drop in between. I am your humble lone wolf Usul, and I am out. That was really weird, kind of cheesy too, but I'm out. And thank you for the late support there, Marty. I greatly appreciate you. Word. Lone Wolf. Ow!